Thank you everybody for joining us today and coming to hear a little bit about the basics of the H-2A program. As Paige mentioned, I'm Andrew Walchuk. I'm a staff attorney with Farmworker Justice. And I just want to first say thank you to the folks at NCFH for all the work that they put into making this happen. So big thank you to Paige, Lupita, Silvia, and the whole team. Also to everyone else at CDM and my colleagues at Farmworker Justice who helped to organize this series for the next few weeks. Also, thank you to Soraya for providing interpretation today. And please do not hesitate to slow us down if we're talking too quickly. So first, just want to say a little bit about our organizations before we jump into the H-2A program. So I will turn it over to you, Ben, if you want to say a little bit about CDM.
Thanks, Andrew, and thanks everybody for putting these trainings together. I think it'll be a really interesting opportunity for all of us to share a little bit about what we know and hopefully increase knowledge in the community about the H-2A program and how to improve working conditions for the hundreds of thousands of workers who come to the US every year to perform this essential work. Centro de los Derechos del Migrante, or the Center for Migrant Rights, is a binational migrant workers' rights organization. We're based in both Mexico and in the US. We have staff in different locations throughout both countries. And our focus is on ensuring access to justice for migrant workers who come to the US on H-2A visas and many other visas, as well as folks who come to the US without a visa. But just really working to ensure that folks who come to the United States to work have better working conditions and can advocate for themselves to improve those conditions, and both through things like litigation and policy advocacy, as well as community education and empowerment. We're seeking to improve the experience that workers have when they come to the United States and ensure that they can access the justice that they deserve.
Thanks, Ben. And Farmworker Justice, for those of you who don't know us, we are an advocacy organization based in Washington, DC. But we work really closely with farm worker serving organizations around the country. We work with farm worker labor unions. We work with great advocacy organizations like CDM, and also organizations providing non-legal services like NCFH and various others. And we, through our policy work here in DC, through our sort of capacity building efforts that we undertake with those organizations, are seeking to empower migrant and seasonal farm workers to improve their living and working conditions, to improve their immigration status, get access to immigration status, improve their health and occupational safety, as well as access to justice. And if there are ever things where you're trying to figure out what's happening at the national level, what's happening with policy on farm worker issues, please do not hesitate to reach out to us, or if there's other ways that we can help out to help build capacity, we're always happy to be here and serve as a resource however we can. But now we'll get to a little bit more about the point of the presentation, which is to learn some about the H-2A program. So this is a program that is, I think, as many of you know, really growing in importance in the agricultural sector. It has really exploded over the last several years, as we'll start to talk about more. But we're going to talk about kind of three main elements. So first, we're going to discuss the expanding role of H-2A in agriculture. So try to give you just a broad perspective of where the H-2A program fits in agricultural labor, where it fits in the broader US immigration landscape, and also just give a little historical context of kind of how it came about, what were its predecessors, what were the issues there. Then we're going to go into the H-2A program as it exists today, and then is going to talk a little bit about worker protections in the H-2A program. So these are really essential things to know. It is an immigration program, but there's a tremendous amount of worker protection provisions built into this program that are really important to know, that are specific and different from those that many other farm workers have available to them. And there are some places where H-2A workers don't have certain options and resources available to them. And then we're gonna go into take a little bit of what we've learned and start applying it. So start figuring out what some of the common violations in the H-2A program are, and help you guys think through just kind of issue spotting. When you interact with an H-2A worker and you're hearing about things that may happen, you don't need to be an attorney to know that something's wrong. And the attorneys are here to really dig in and say how things are wrong. But you guys are many times on the front lines of seeing these violations firsthand or hearing about them firsthand. And we want to make sure that you guys have the resources that you need to help those workers and make sure that they're able to escape situations of exploitation and get access to the legal resources that they need. So at the end, just to give you a little sense of how we're planning to run things, at the end, we are planning to have some time for questions and discussion. But as we go along, an hour and a half is a long time to listen to just me and Ben, and we really do want to hear your questions. And we know that you guys probably have a fair number of questions. It's a very complicated program. The US immigration landscape itself is very complicated, and this is a particularly complicated component of it. So please do feel free to raise those questions. We'll be monitoring the chat, and Ben will break in, or I'll break in if there are questions that we think need to be answered at the moment. But also kind of in between each of these sections of the agenda, we're going to take some time and go through those questions and try to get you all answers. And also, if there's something that you've seen or experienced with a worker that is particularly on point, please do feel free to share that in the chat and let us all know. We want this to be a space where everyone's able to really contribute. But with that, I think we did just want to get a little bit better sense of who all's here. We have 100 people here. It'd be great to know a little bit about you. So we have a few poll questions, if we could share those now, just to get a sense of what your experience is with the H-2A program. So curious if you've ever worked with workers on an H-2A visa, kind of where in the country you're coming from, and how much you'd say about the H-2A program coming into this. Oop.
The poll results are on the screen. You should be able to see them now.
All right, so it looks like, as I expected, the majority of you have worked with H-2A workers. That's not terribly surprising. I imagine those of you who have not probably will sometime in the future, given the expansion of this program. Most of you coming from the South, Northeast, Midwest. Don't have a lot of West Coast people. Okay, that's good to know. And most of you feel like you know most of the basics, a lot or only a little. Those of you who are brand new to H-2A, hopefully this is going to be particularly educational to y'all. But I do think that kind of what we're going to go through today, hopefully, helps you take what you know, for those of you who do know some, and kind of put it in a broader perspective and really operationalize some of it in terms of how to use these protections, even if you aren't an attorney, to really think through and help and advocate for those H-2A workers that you do come into contact with. All right. Well, great, then we will go ahead and get started. So first, I am going to talk a little bit about kind of the expanding role of H2A in agriculture and how this fits in kind of the historical context and how it fits in with the broader agricultural workforce. So as most of you are probably aware, there's about 2.4 million farm workers estimated in the US. We don't have the best numbers on this, but this is kind of the best data that we've gotten from the US Department of Agriculture. And last year, so that was a 2017 number, but last year we have the numbers, we have real great statistics on the number of H2A positions that were approved by the government. Because this is a federal government program, everything has to go through the federal government for H2A workers to come in. We do have pretty decent data on who is coming in this program. And last year, we had 317,000 H2A positions that were certified by the Department of Labor. So that's a really huge number. That makes this one of the biggest visa programs that is administered by the federal government. And it means that now H2A workers are about 1 in every 7 farm workers is holding an H2A visa. And we only, as I'll get into in a few moments, we really expect this proportion to grow because kind of the overall number of farm workers is decreasing somewhat, and we expect the number of H2A workers to increase for a number of reasons. So first, I want to talk a little bit about undocumented workers in agriculture, so that we can think about how their concerns may differ from those of H2A workers. And now getting accurate numbers on the percentage of undocumented workers is incredibly difficult, as you can imagine. First of all, we only have broad estimates for the overall number of farm workers. And then on top of that, you have undocumented farm workers who are often, understandably hesitant to identify themselves as undocumented. But what we have from a survey that the Department of Labor runs called the National Agricultural Workers Survey, some of you may have dealt with it before, but this kind of gives us our best estimate. And so the most recent data from them says that about 36% of workers living in the United States report being undocumented, of farm workers living in the United States report being undocumented. That is a pretty big change from more recent years. So just 2 years before this, the number was much closer to 50%. And years prior to that, we have seen it even higher than 50%. There's a couple reasons that it may be where it is now. This was a survey being conducted during the early years of the Trump administration, so there may have been more hesitance to report being undocumented. But we do think that the proportion of undocumented workers in agriculture is actually decreasing over time for a variety of reasons. But really importantly, this chart that you see here does not include H2A workers. That survey only talks to workers who are living in the United States. It specifically excludes H2A workers. So this is really just a snapshot of the people who are living and residing in the United States and live here permanently. And that other legal status there could be people who have DACA status or people who are seeking asylum or something like that. But still, this is, to have 36% of the workforce be undocumented is not common in many industries. This makes agriculture, as most of you are aware, it makes agriculture one of the industries that has the highest proportion of undocumented workers. Now, that said, most of those workers have been living here for a very long time, and they're very well firmly settled in the United States. The vast majority have been living here for more than 15 years, as you can see from this chart. But this also means that a lot of the agricultural workforce is aging, and we'll get into that and kind of the role that plays in the rise of H2A. But for those workers who are here, they're vulnerable in a lot of different ways. It's very difficult to find new employment. Working without authorization it can be a barrier for other immigration relief, but it's not a crime in and of itself. But hiring undocumented workers, employers can commit a crime by hiring undocumented workers. So it's a crime for them, not for the worker. But as we all know, it's an open secret that we have this huge number of undocumented workers working in agriculture. But still, the fact that those penalties are there makes it harder for undocumented workers to find new employment. So that makes them very vulnerable, that they don't want to lose a job. There's always this threat that I think, again, we're all aware that the employer can call ICE. There is literally an ICE tip line that people can call and report people directly to ICE, and it won't immediately necessarily, it doesn't automatically result in deportation, but it really puts a target on that person's back. And that does not make for a fair, balanced relationship between a worker and their employer when their employer can hold that threat over them. We see the widespread fear of reporting violations to authorities, just a hesitance to interact with government authorities. Understandably, people are concerned that their information about being undocumented may get back to ICE and immigration authorities. It also makes it really difficult to organize workers and exercise that right to freedom of association when there is constantly this threat being held over them, people not wanting to draw attention to themselves. Really importantly here, as I'm sure most of you are aware, undocumented workers are excluded from access to most civil legal services because many civil legal service, legal aid programs receive a certain kind of federal government funding. They have a limitation that they're not able to provide services to undocumented individuals. There are groups who provide legal services that do not receive that funding, who do not have this limitation. But for the most part, many of the biggest groups that we're familiar with of legal aid groups aren't able to help undocumented workers for that reason because of their immigration status. And really importantly, this one you don't hear as much. I think it's obvious, but it has real impacts of the lack of a right to vote. When politicians don't consider you a constituent, when they don't see people being able to kind of have a threat against their continuation in office, they care less about that constituency. And this is always something that is going to make immigrant workers, undocumented immigrant workers, particularly vulnerable because it's hard to get that political power behind them. So those are all sort of vulnerabilities of the undocumented workforce. And the reason that I want to talk about that is because even though H-2A workers have legal status, in many ways, they have many of these same vulnerabilities. And I think that's often lost in the conversation about the H-2A program. So now I'm going to shift a little bit to the history of this idea of bringing guest workers, migrant workers into the country. So the sort of antecedent to the H-2A program is what we call the Bracero Program. And again, I know many of you are familiar with this history, but I think it's really important for understanding the context of the H-2A program that we have today. So this is a program that began during World War II. There was a shortage of US workers as many were being sent off to fight in the war. And so we had a series of agreements between the US government and the Mexican government to bring in workers from Mexico. This had actually happened before. This also happened in World War I. So there was kind of a mini Bracero program then. But this really became a really huge program coming out of World War II. And unlike today's H-2A program, it was a series of agreements. So the Mexican government was very closely involved in setting up the sort of parameters of this program. But it brought in, over the course of the 22 years that this program existed, it brought in more than 4 million Mexican workers into the United States. And many of the protections that we see today were in the H-2A program were actually, purportedly in place during the Bracero program, during the 40s up until the 60s. many of the same, worker protections about getting paid a certain amount for your contract, things like that, were in place. There were also wage protections. Minimum wage in many contracts was around 30 cents an hour, which is close to $5 in today's dollars. But as we often see today, there was just widespread non-compliance with these rules. And this really terrible treatment of the workers who were coming in. And just as an example of how people were treated, this photo that you see here is a photo of what were called fumigations, and they many times would spray workers who were coming in across the border. They'd spray them down with DDT, other really harsh chemicals that we know today are incredibly toxic. And this was just the start of really routine, terrible treatment of workers. And this is something that we've continued to see. This is a treating of these workers as if they're lesser than, as if they're, we only see them for their labor. It's a problem that has been endemic in these programs ever since they began. And there's also this idea of it as being sort of very disposable labor. At the same time that they were bringing in all these workers through this program, they were deporting millions of workers. They think about 1 million people were deported in the mid-1950s in a really racist program of mass deportation. And these were workers who could have been doing these jobs, but again, they'd rather bring them in under these really exploitative contracts and send people back to Mexico rather than providing work to people who are here. And they even deported H-2A workers. This was really a time of poor enforcement of the rules, a time of a lot of racism, and this program was just rife with it. And so as soon as the war is over, we started seeing more of a backlash begin, and then going into the 1960s, we finally see an end to the program. Part of this was because people were bringing light to the abuses that were occurring, but part of this was also because there was more effort and more concern about the effect that the program had on US workers. And so you kind of had this confluence of issues come together, and Congress decided to end the program in 1964. But I do want to just say this, so while many people talk about this as the predecessor to the H-2A program, I think it is really kind of the model to think about of the US turning to this kind of deportable labor, this exploitable labor when there was a labor shortage in the US, and then not treating those workers well. Like, we see that as really the antecedent to today's H-2A program. There is the actual H-2 program was also born during this time, and I'll talk about that in a second. But I just one thing I want to flag again in terms of issues that we see continuing to today. There were promises in the Bracero program that once workers returned to Mexico, they would get wages and reimbursements sent back to them. And we saw just, again, widespread non-compliance with that. Workers have been fighting for decades after the end of the Bracero program to get access to money that they were entitled to from their work in the United States, and they were never able to access. So this is just a continuing problem that we've seen in terms of workers once they leave, being able to access legal remedies and access those wages that they're entitled to. So the H-2 program began in 1952, kind of alongside the Bracero program. It was really targeted at Caribbean workers. Many of them came in to work in sugarcane in Florida, but it was really small for most of its history. So it was only a few thousand workers each year. In 1986, we get what we have today of the H-2A and H-2B programs. The H-2A program is dedicated to temporary and seasonal agricultural work, and the H-2B program is temporary and seasonal non-agricultural work. So we often see folks doing things like landscaping or working in certain seafood industries who are in the H-2B program. But the key element of the H-2A program is that there is no cap on the number of visas. And this makes it unique among most immigration programs. And it makes it a major target for employers who are wanting to bring in workers. They see this sort of uncapped labor program as a way to address their labor needs. And as we'll discuss, there's a reason that they often prefer H-2A workers to US workers. But it does need to be technically temporary or seasonal work. And it is a temporary visa with no path to permanent immigration status. And you'll see here that, over the past 5 years alone, the program has doubled in size. Back in 2010, it was about 56,000 workers. So it's really, it's almost, I guess now 5 to 6 times the size it was just in 2010. So really explosive growth in this program. And we kind of expect that to continue, that trend to continue. So why is it growing? The first one, as I was discussing earlier, is the fact that employers can be criminally liable for hiring undocumented workers. So the H-2A program allows them to hire vulnerable workers without facing those legal consequences. So there is a real incentive for them to hire H-2A workers over undocumented workers. And many of them, as they learn more about the program, are seeking to make that transition. But it isn't just a legal compliance reason that the program is growing. We see the domestic agricultural workforce is aging. That is something that all the data bears out. Now the average farm worker, according to the Department of Labor survey, the average farm worker is over 40 years old. So as that workforce ages, employers are looking for new sources of labor. They're looking for new farm workers, and there are not as many young workers coming into agricultural work in many cases because the conditions are so poor. And one of the key things is that the H-2A workforce is very easily exploited. Because the employer has so much control over the visa. They have a similar level of control that they would with an undocumented worker, but they don't have the concern of those criminal penalties. They're often able to evade accountability for discrimination in hiring, which Ben will talk more about a little later. And that's both in terms of age and in terms of gender. So we see it's very common that H-2A workers are young men coming into the US, and that has real appeal for the employers. And they're able to evade accountability because much of that discrimination is hiring that's happening abroad. And there's also strong political support for it from both sides of the aisle because of business interests, but there's also a sort of xenophobic, racist component to this. I have a quote here from a former Secretary of Agriculture who was talking about why he likes the H-2A program so much. And he said, it doesn't offend people who are anti-immigrant because they don't want more immigrant citizens here. So he just kind of said it out loud of the reason they like the H-2A program is because it's that temporary visa program. It doesn't allow for people to have a path to status. It doesn't allow for people to actually have a path to becoming part of, the citizenry here in the United States. And so there's real political pressure from both sides to expand this program. So a little bit about how it works. The Department of Labor, one of the key elements here is the Department of Labor has to certify 2 factors for every H-2A job offer. It has to say there are not sufficient workers who are able, willing, qualified, and available to do the work in the United States. And it also has to certify that the employment of that worker will not adversely affect the wages and working conditions of workers in the United States. So there's, some recognition here from the Bracero era, from past periods, that the vulnerability of these workers could make it harder for US workers to compete, to raise their wages, because they're often, if an employer is able to say, well, I can hire this person who's going to work for very little money, who isn't going to care what I'm doing, because that worker is so vulnerable, it makes it harder for the US worker to stand up for themselves in that case and say, no, I'm going to demand better wages, I'm going to demand better working conditions, because the employer is able to, validly say, yeah, you're very replaceable. Look, I have this other worker that I can bring on. And so this is designed to help address that. As we see in practice, it often doesn't work out that way. More than 95% of applications to the Department of Labor, when it's certifying these two factors, the department certifies that these two factors are present, and therefore it's okay to bring an H-2A worker. So we don't see a lot of scrutiny of these petitions. And then there's this complex process that kind of bounces around the government. So you'll see what's called a job order. Sometimes you'll hear a clearance order. This is really the job offer. This is the employer saying, this is what I need to have done. This is the wage that I'm going to pay. And they have to give that to the Department of Labor to certify. And the Department of Labor and the state workforce agency, which vary, the name of the state workforce agency varies depending on your state, are going to say, okay, we certified this offer, but you have to recruit US workers. So you have to put it out there and recruit US workers. So you'll see it go online on this thing called seasonal jobs. Sometimes the state workforce agencies will advertise that job out there. And they'll continue to advertise that job for a certain period of time. And then the H-2A employer, if they have found no US workers, is able to bring in the H-2A workers. And that portion, they file a petition with US Citizenship and Immigration Services, which is part of the Department of Homeland Security. So we have a lot of agencies, a lot of alphabet soup here, all involved in this. So they've put out the job offer. The Department of Labor really handles that job offer piece. But then when it comes to the actual visa, they have to request permission from the Department of Homeland Security to bring that worker into the country. And then once they have that permission, the worker themselves has to get a visa from a US consulate abroad, which is where the Department of State comes in. So we have we have a really broad array of agencies who are in charge of administering this. And that's part of the reason that accountability is really difficult in the program, because sort of the authority for the program is so spread out. And then finally, the workers travel to the US. Once that whole process is complete, that's when they come here. That's when we really start to have contact with them. And the visa is for a maximum of 1 year, but it can be extended for up to 3 years. But they have to go through that same process, this step-by-step Department of Labor, Department of Homeland Security, Department of State, for each of those visa extensions. So some of the basic dangers about the H-2A visa is that fact that it's tied to a single employer. So this is where you really have that similarity between undocumented workers and H-2A workers. You have a visa that if the employer fires you, ends your job, that visa is no longer valid. So they are both sort of deportable in the same way. They both face this fear. And just last week, we had a story from an Idaho potato farm where the Department of Labor came in and found that the farm had failed to pay over $150,000 in wages and had told those H-2A workers, well, if you don't accept these lower wages, then we're going to fire you and you will be sent back to your home country. So we see that same sort of don't complain, and if you complain, we'll deport you, that we see with undocumented workers, even though it's a legal visa. We also see a lot of abuses in recruitment, which Ben will go into more later, but that discrimination in hiring, we see illegal fees charged, recruiters that have a lot of control of the system. And a lot of workers are coming here in debt because of that recruitment process, because of those recruitment fees, which makes them even more vulnerable. And because of this, we see a lot of labor trafficking. the labor trafficking hotline has said recently that a quarter of all its calls across the country came from H-2A workers, which is just really an astonishing number when you consider the range of workers that are in this country. And then many times they're supposed to be provided housing, but it's really inadequate. I just saw there was a question about the number for the trafficking hotline, and we'll provide that at the end. I believe it's in our resources page. And so, yeah, we had this slide before about vulnerability of undocumented and H-2A workers, about vulnerability of undocumented workers. Here, I just want to show that many of these are the exact same concerns. So that's the key thing that I really want to get across, is that, even though it is a legal status, the vulnerability is still absolutely there. And many times these are workers who come in with no community connections, which is the other big thing. They are coming in for this temporary time, whereas many undocumented workers have been here for decades, have connections in the community, have family members who can reach out to get other resources. A lot of these workers are incredibly isolated. And so that is where I think y'all really come in as being some of the key contact points who may be able to identify some of these issues, who may be able to inform these workers of their rights. One key thing that you'll note here, though, is H-2A workers can receive those legal services from government-funded legal services organizations. So this is a really important note, and I want to make sure when you're kind of thinking about if you can refer people, this is a key thing to know, is that this is a population those groups can help. They can even help those H-2A workers once they've returned to their home country, and they're very eager to do it. They do a lot of it. So, California Rural Legal Assistance, Texas Rio Grande Legal Aid, a lot of these legal aid groups do a lot of work with H-2A workers, and they're going to be able to try to work with those workers even if they've returned. And CDM, I think, plays an important role there because of CDM's presence in Mexico. They've done some really great work at helping to connect workers with advocates here, helping advocates here think through how to kind of represent workers across national boundaries like that. But with that, I will turn it over to Ben, does anyone have any questions sort of about this broad overview of the H-2A program, about sort of the differences between undocumented and H-2A workers, or any of the history of the program?
I don't know if it's okay for us to unmute.
Yep.
So Andrew, you mentioned earlier, for a variety of reasons, there's been a decrease in the number of US farm workers. And I know you mentioned age, the increasing average age. Was there another factor or two in that variety of reasons that you could share about the decrease in the number of US farm workers?
So part of it, we think, and just from talking to some of the experts who work with these numbers, is US farm worker, undocumented workers sort of being pushed out of agriculture by—
Sure, I put ground beef on the spaghetti meat today.
By H-2A workers. We see an increasing number of employers who may have previously hired undocumented workers who are now hiring H-2A workers as the program has really grown in size. So that's another of the big sort of dynamics that we've been seeing. And there's also, some other industries are mechanizing. So we've seen this with certain products in the past. One of the reasons that the Bracero program ended was some of the key industries like sugar beets and cotton actually mechanized, so they didn't need as much manual labor from workers. And we see sort of increasing technology and mechanization in some different agricultural industries that leads to kind of a decrease in the need in those sectors of agriculture, if that makes sense.
Absolutely, thank you.
Astrid, did you have a question?
Can I ask you a question?
Oh, I'm sorry. Well, more than a question, is something that I want to mention, is that sometimes also H-2A workers, like their contract doesn't have a specific point that what it says that extra hours are not allowed, like they don't receive payment for extra work. And domestic farm workers will not be like agreed to that, you know, like to work more than extra hours that they will not get paid for. I don't know if that makes sense, but that means that H-2A workers can get vulnerable to be exploited, or to work extra hours without remuneration when domestic farm workers know that they should be getting paid for this. So I think that might be also a reason why some numbers have been going down with domestic farm workers.
I think that's absolutely right. And I know Ben will get a little bit more into some of those components. But that I think really exemplifies this idea that employers often prefer the H-2A workers because they are more vulnerable and they're easier to exploit because they don't have the same access to information and resources that many of the domestic farm workers do. So thank you for raising that. I think I heard one other person had a question.
Agnes, if you are speaking, it looks like you're on mute.
All right.
Sorry about that.
Okay.
Okay, I got it. It's about the H-2A visa. I had the information that only is good for 10 months and not for 1 year. And when you say 1 year, really, I would like to check this out again.
Yeah.
Where I can find the information.
Yeah, so that's actually a very good point. And I think that I did not explain that well enough. So it can be for up to a period of a year, but the period of validity of the visa is tied to the job offer. So if the job offer is 10 months, then that is the period that the visa will be valid, but it cannot be valid for any more than 1 year. It has a maximum of a year of validity. Does that answer your question, Agnes? So it's really the period that the worker is eligible to be in the US and have a valid H-2A status is the length of that job contract. But this is just a limit on how long that job contract can be and how long that period can be.
And I think that what the Department of Labor says about this is that although the law limits the maximum period of validity to 1 year, generally it's 10 months or less because of the fact that the jobs have to be temporary or seasonal. It's a rare case in which it would be longer than 10 months, but certainly can't be longer than 1 year.
Yeah, can I say something too? Can you hear me?
Yes.
Yeah, the other thing with the visa H-2A is they cannot, because some of the workers that they already know the system too, so they try to apply with the other contractors when the one contract finish. But the other thing that they don't know is that they cannot work 3 consecutive years. They have to go out of the United States at least for 3 months and then come and apply again. And sometimes they don't know and they just keep doing it.
Yeah, that's right. And I think we'll get a little bit more into kind of some of the problems about extending and extensions. The fact that employers are kind of in control of extensions is another added difficulty that makes workers more vulnerable. But I think Anna will have you ask a question, and then I want to make sure we can get to Ben, who is going to talk a little bit more about some of the protections and some of these added vulnerabilities that workers face. Anna, if you want to unmute, you can.
Anna, if you're having a hard time unmuting, you can also put it in the chat and you can get to it afterwards.
Can I say that also I have another question?
Yeah, I do have a question too. Whenever I have a chance.
Let's go ahead and put them in the
Yeah.
chat now, and we'll get to them during the Q&A section, if that's all right. So we can move along to the next section.
Okay.
All right. Thank you, Andrew, for giving that really helpful historical and kind of legal background to the program. If you can just skip forward to the next slide. So I'm going to spend some time talking a bit about the protections that are provided under the H-2A program, some of which are unique to H-2A workers, some of which are also shared more broadly in the agricultural worker context across the board. But some of these protections are specific to H-2A workers and are designed with the idea that H-2A workers may be subjected to certain vulnerabilities that the broader agricultural worker population is not subjected to. And keep in mind that this is a very 30,000 feet summary. We're keeping it somewhat superficial at this point. This is an area of law that many of us dedicate an entire career to. So obviously in 20 minutes or so that I'm talking, I'm not gonna be able to touch on everything. But my goal is just to highlight some of the most important protections that are out there, and then talk a bit about what are the violations that advocates and probably many of you all are commonly seeing in the program, and then talk a bit about how we identify those violations. So I'll just jump right in. H-2A workers, unlike the general farm worker population, have one very important right that they have is a right to free housing. H-2A workers obviously coming for a short period of time and generally are not going to have the wherewithal to be able to find their own housing. So the program puts the obligation on employers to provide workers with free housing. And as we'll see, that's of course an area where there sometimes are violations, and sometimes workers are actually required to pay for their housing, despite the fact that the employers are supposed to provide it. The housing itself is subjected to certain health and safety standards, and it's supposed to be inspected before H-2A workers arrive in the US by state workforce agencies. That generally happens, but the quality of the housing, as many of you probably know, varies a lot, from housing that is in pretty good shape to housing that's really in deplorable conditions that nobody would choose to live in. Another right that H-2A workers have is a right to reimbursement of their costs for coming to the United States. There are particular to when that has to happen. But generally speaking, I think the idea you want to keep in mind is that H-2A workers should not have to pay to get to the United States, or at some point during their employment with their H-2A employer, they should be reimbursed for any costs that they had to pay out of pocket in getting to the United States, whether that's the fees that they had to pay to the consulate to obtain their visa, or it's costs that they had to incur to get from their home communities to the consulate, or from the consulate to the work site in the US. All of those costs are ones that ultimately an employer is supposed to bear. There are some exceptions to that that we won't get into right now, but that's the basic idea, is that the employer has to pay for workers to be able to get to the United States. Another important protection that we call the 3/4 guarantee is this idea that workers on H-2A visas need to be paid for at least 75% of the hours promised in their work contract. So that job order that Andrew was talking about earlier outlines both the hours per week that a worker will be expected to work and the dates of employment that are expected. So you can do kind of a simple calculation and look at, over the course of a season, if a worker is promised, say, 1,000 hours of work, they're entitled to be paid for up to 750 hours, regardless of whether they actually work those hours. So it might not be immediately intuitive why this is so important, but oftentimes you have workers who come in and are not immediately put to work, or there's lots of rain and they can't go into the fields for a certain period of time, or they're working for a farm labor contractor whose work with a particular grower falls through. And the idea is that workers have to put a lot in to come to the United States to work on these to work on these jobs. And the obligation is on the employer to make sure that they receive at least this minimum 75% of the wages that they were promised. Again, this is an area where you often see that employers don't hold up their end of the bargain and they don't actually comply with this requirement. But this is one of the important protections that is in place for H-2A workers. Another one is this prohibition on fees, and this kind of goes along with the reimbursement of travel costs. What we have seen frequently for H-2A workers and visa workers generally is that oftentimes they have to pay a labor recruiter, or sometimes even employers directly, to get a job opportunity in the United States. And there is a very explicit prohibition written into the H-2A program rules that says workers should not be required to pay any sort of fee. In fact, employers actually have to, in any contract that they have with a labor recruiter, they have to explicitly prohibit the recruiter from charging any fees. So that's an important protection. It's particularly important because, as you can imagine, if a worker has to pay out of pocket $2,000 or sometimes more than that before they even get to the United States, it means that they're arriving indebted, and it subjects them to coercion. In other words, they feel obligated to stay in their job to pay back whatever loans they may have had to take out or whatever debt they went into in order to come to the United States in the first place. It's a protection that makes a lot of sense when we think about, what is the purpose of a job? Is to make money to support your family, put food on your table. And the idea that you have to pay for a job is really counter to that very, very fundamental idea of the purpose of work. The H-2A program also prohibits retaliation for workers speaking up or seeking to enforce their rights. And that's really a critical protection that ensures that workers who come forward and have the bravery to seek to protect their rights can do so without negative consequences. There was also a question earlier about the work contracts. So the program requires that employers provide, before the worker actually goes to their visa interview, provide a worker with a written contract in their own language. Oftentimes that contract is going to be the same document as the job order that about earlier. And the important thing about that is that the job order will lay out the basics of what a worker should expect. So where am I going to be working? Who's my employer? What are the wages that I should expect? What kind of work am I doing? What are the hours that I have to work? Those very basic things that anyone would expect to know about their job is something that oftentimes workers don't know about or are misled about. So having that work contract in advance is really a critical piece of information for workers, and is often the basis for legal claims down the road when a worker finds that what they expected in the job is not what they actually ended up being faced with on the ground. If we go to the next slide, Andrew. Another critical protection in the H-2A program are protections related to wages. So generally speaking, H-2A workers are going to be entitled to a wage that is above the federal minimum wage. As many of you probably know, federal minimum wage has been stuck at $7.25 an hour for a number of years. H-2A workers are, I think, in every state at this point entitled to a wage that is higher than that federal minimum. And the H-2A program lays out three different bases for, I guess four bases for the wage that might apply to an H-2A worker. It could be the applicable state, federal, or local minimum wage. It could be what's called a prevailing wage. It could be a collective bargaining agreement wage, so a wage that's agreed to between a labor union that represents workers and an employer or a group of employers. And then the last one is what's called the adverse effect wage rate, or the AWER. And that's really the one that you see most often applying for H-2A workers. So it's always going to be at least that wage. And that, as I said, that's a wage that's going to be, and I think in all cases at this point, higher than the federal minimum wage. And as you'll see in the slide there, the national average is at this point more than double federal minimum wage. And the idea with the adverse effect wage rate, that's a wage rate set by based on surveys of agricultural worker wages, with the theory that H-2A workers shouldn't be making wages that depress wages for the farm worker population more generally. As you all probably know also, H-2A workers are almost without exception not entitled to overtime. So what that means is that H-2A workers, if they work more than 40 hours in a work week or more than 8 hours in a day, they're still going to be making most likely that same adverse effect wage rate, or should be paid at least that amount, but they don't have to be paid time and a half for their work, which is probably the subject of the presentation, but it's a longstanding injustice that many of us have been advocating against. And states, or not many, a few states have implemented and state level law for farm workers to receive time and a half for their overtime work. But at the federal level, that is still the case, that they're not entitled to overtime. We go to the next slide. Okay, so that I previewed the first point on this next slide. Another important sort of injustice or exclusion of H-2A workers is that they are not entitled to the protections of the Migrant and Seasonal Agricultural Worker Protection Act, or AWPA, which is the main federal law protecting farm workers. It's kind of terrible irony at this point, given that H-2A workers are making up such a large percentage of the agricultural workforce. But that is the case, that the APA expressly excludes H-2A workers from its protections. This point about H-2A workers not having a private right of action is a little bit of legal jargon, but basically what it means is that if an H-2A worker suffers a violation of their contract or other violation of their rights under the H-2A program, the rules, that even though they are federal rules, don't give them a right to go into federal court and sue their employer for those violations. There's a number of other laws, like the minimum wage law, anti-discrimination laws, anti-trafficking laws, that do allow workers to go into federal court to sue their employers, but the H-2A rules don't allow them to do that directly. And then another issue that we see really frequently is this issue of farm labor contractors. So many agricultural employers and growers will use these smaller operations whose work is basically to seek out workers to do short stints at different farms, providing their labor. And this is advantageous for growers because they can find workers, and they often try to sort of wash their hands of any responsibility to workers. The problem for workers is that often these FLCs don't have resources or commit violations of the workers' rights, and they will often sort of disappear once the workers try to seek the wages that they're owed, or seek other types of accountability for the violations that they suffer with these FLCs. So that's an issue that I'll look at frequently. The other thing is that many of these protections that we're talking about are not they're not statutory. So what I mean by that is that they're not part of the law that Congress passed and the president signed. They are rules that are implemented by the Department of Labor to implement this program. And so what that means is that they are subject to the whims of a particular administration. And what we saw in the last administration was a significant effort to pull back some of the rights that had been provided to H-2A workers. Fortunately, many of those rules were not ultimately implemented, but that's it is symbolic of this idea that many of these rights are somewhat precarious and could be taken away by an administration that is more interested in supporting the rights of agricultural employers in that industry. We can jump to the next slide. Okay, so I'm seeing that we have a little more than 20 minutes left in the presentation. We're going to talk a little bit here about identifying violations of H-2A workers' rights. We have a couple of hypothetical scenarios that we're going to put in front of you all and give you the chance to jump into some breakout rooms. We may only get to one of them depending on the timing, but I'll just give you a few thoughts about common violations that we see really briefly. And some of this may be completely intuitive to all of you because you see it every day in your work. But some of the things that we see just really commonly among H-2A workers are, first of all, this idea of paying to work that I talked about earlier. And that can come in many different forms. It can come in the form of recruitment fees that workers have to pay to a labor recruiter or employer in their home country, which is oftentimes 90+% of the time Mexico. Or it can come in the form of wages that they have to pay back to their employer. I personally and many others have seen lots of cases where workers literally have to cash their paycheck with their employer and then hand back money in cash to their employer on a weekly basis. And then there's all sorts of more subtle forms of wage theft that occur. So whether it's workers not being paid for the hours that they work beyond 40 in a work week, or it's workers being required to pay for their housing. There's all sorts of schemes that employers engage in to basically push some of the costs of participating in the H-2A program off onto H-2A workers. Another pervasive problem that we see in this program is this issue of retaliation. So when workers stand up for themselves and seek to protect their rights, whether they go to their employer or they seek help from the Department of Labor or come to an organization like mine, we often see, and one of the #1 concerns that were expressed to us is what's going to happen to me when I speak up, because they so often see how employers threaten them with consequences, whether it's immigration consequences and deportation, or harm to them and their families, or simply being fired. Those are the types of fears that are borne out often by the experiences of H-2A workers and others who stand up to protect their rights. In the agricultural industry generally, I think it's perhaps not surprising to many of you that issues surrounding sexual harassment are really widespread and under litigated or under exposed. It's often very difficult for workers who experience sexual harassment to come forward, given the dynamics of the program and given workers' vulnerability. And I should say, and I think that Andrew touched on this, but with respect to all of the violations that we're talking about, a lot of this in the H-2A program, in our view, stems from the fact that workers, when they come to the US on an H-2A visa, are tied to one employer. So it's not as if when you are in an employer, working for an employer and are subjected to these types of abuses, you can just go down the street and get a different job. The visa itself requires you to only work for a particular employer. If you quit your job, you no longer have immigration status and you are supposed to return to your country. So that puts workers in a very difficult position. And employers know this and they take advantage of it and take advantage of workers given this sort of fundamental structural problem with the program. Andrew spoke a bit about this issue of recruitment discrimination. We see in our work in Mexico widespread fraud in recruitment where workers are often promised jobs that don't exist and have to pay money for opportunities that disappear. We see pretty widespread health and safety concerns, which I'm sure many of you all see in your work, where workers are subjected to, for example, exposure to extreme heat and long working hours without access to adequate shade or water. During the pandemic, we've seen many instances of outbreaks in farm worker housing or in the fields or in packing sheds. and these housing conditions I spoke about earlier are also quite common. I realize I'm going very fast. I'm just being trying to be aware of the time here. So we'll jump ahead to the next slide. A huge issue that's, I think, of increased or getting increased attention among the advocacy community is labor trafficking. These are the bullet points on this slide, give you a sense of some of the red flags for labor trafficking. It can be a difficult type of violation to identify because it's not one, it's unlike, for example, wage theft, where you know this person should have been paid $15 an hour and they were only receiving $7. The violation is much clearer. Labor trafficking often involves a more nuanced legal analysis. But anytime you have a worker who you're speaking to whose passport was taken away or was told that they couldn't leave their housing during certain hours or threatened with violence or things of that nature, it's a situation where we are concerned about labor trafficking and forced labor. And it's something that we would want to look at closely and figure out options for that worker to get them out of that situation. All right, I'm going to skip over this Operation Blooming Onion, but you all should take a look at recent press reports about this huge prosecution involving dozens of H-2A employers and hundreds of workers. But that's all I'll say about it for right now. I think it's just representative of some of the broader issues that we see in the program. All right, so we're going to do a very quick, I think maybe about 7 or 8 minute breakout room. We'll just go with the first hypothetical. I don't think we'll have time for both of them. But what we're going to do is give each of you the opportunity just to read the hypothetical briefly. And the idea here, this is what we do as lawyers every day, as law students, as paralegals, or other folks that do advocacy with workers. We have workers who come to us seeking our help, seeking our assistance to figure out what their legal options are. And they tell us what's happened to them. And our job is to take a look at their situation and evaluate what are their legal options. So the idea here is not that there's going to be any correct answers. It's more like an opportunity for you all to briefly brainstorm what are the issues you see here, just based on your intuition and either in-depth or very limited knowledge of the H-2A program. What do you think is missing? What else would you want to know? And any thoughts about resources or referrals that you might want to consider in this case. So, so we will do, I think we're going to go for about 8 minutes into breakout rooms. You all will be in groups, and just take some time to discuss together what else you'd want to know, what kind of issues or violations you see here, and any thoughts about resources that might be helpful in this case. So I hope you enjoy it, and we'll come back in about 8 minutes to briefly discuss any thoughts you all have.
All right, I'm going to open up the rooms.
Take a look at a real situation and discuss kind of what your approach might be and what else you'd want to know. So what we'd like to do is just invite anyone who wants to highlight really quickly anything that came up in your conversation. And you could do that either in the chat or unmute yourself. And since we only have about 5 minutes left in the presentation, we're going to kind of combine this with any general questions that you all have about anything that came up during the presentation. So feel free to, like I say, put your question or comments from the hypothetical in the chat. And if you have other questions that have come up during the presentation, feel free to speak up or write it down. We'll try to get to everyone we can in the next few minutes.
Really quick, if I may, I work with the State Workforce Agency, and one of the things that I wanted to highlight really quick is developing a relationship with the State Workforce Agency. There's a position called State Monitor Advocates, and so the State Monitor Advocates are tasked for advocating for the rights and protections of migrant and seasonal farm workers and H-2A farm workers, and the State Workforce Agencies are supposed to have an outreach program that visits farms and that also locate farm workers wherever they go, wherever they are. So developing that with that relationship with a state workforce agency will be beneficial, because if this employer and this blueberry picker does this on a continual basis, we can discontinue services to that employer. And that means that they will no longer be able to bring H-2A workers into this country. And that's a powerful tool that state workforce agencies have. And I wanted to present that to all of you here, that is a powerful tool that you can leverage, and that can really put a hurt on H-2A common violators.
Yeah, that's a really great point. Thank you. I can't actually, is that Abdalis?
Yes, that's me.
Okay, great. And what state are you in?
I'm in South Carolina. I'm actually the state monitor advocate for farm workers in that state.
Oh, wonderful. Well, thank you for joining, and thanks for that comment. I think it's important, both of the state workforce agencies and with both federal and state enforcement agencies to develop those local and national relationships to ensure that there's sort of this cross-pollination between advocates and both in labor rights and health, and these agencies that are charged with ensuring that H-2A workers' rights are respected. So thanks for that comment. So I see a number of comments in the chat about issues that came up in the hypothetical. Definitely this question of whether the worker knows of other workers in the same situation is always a critical question for us to consider, and is one that's going to any advocate considering taking on a case for litigation or other form of representation is going to want to know whether this is, a situation that's unique to that worker or something that's more widespread. In most cases, when something like this is happening, it's going to be more widespread, and being able to talk to more workers is always going to add power to a case. I see, comments about fraud, coercion, and retaliation. Certainly, when workers raise their voices and speak up about concerns about violations of their rights and then suffer consequences, that's always something that we want to look into. So it sounds like there was some fruitful, some good conversation about the concerns that were raised from this case, which I'll say is a fictional case, but is informed by the stories of many workers that I and others have worked alongside in our work. So I see that we just have a couple minutes before 1:30 Eastern. So I think we're just about to finish up. I wanted to go if we can just go briefly, Andrew, to the resources slide. I'm not going to talk in any detail about these, but this is a list of agencies and organizations that are potential useful resources for you all or for workers who you come across, ranging from a few of the federal agencies that have enforcement authority over H-2A workers' rights, to the National Human Trafficking Hotline, to my organization. We do free legal intakes, case evaluation representation for hundreds of workers every year, many on H-2A visas. So that's a resource that's always available. And then these websites that a couple of which are sort of offshoots of my organization that can provide important information about H-2A worker rights, and also potential for job opportunities for H-2A workers. Yes, nationwide. And then I think that's all on my end, unless anyone has any last minute questions that want to raise.
I have one question.
Go ahead.
About housing. Since H-2A workers are not protected under APA, who certifies the housing, and what are the rules? What are the rules for them?
Yeah, it's still the state workforce agencies that are doing those housing inspections, and the rules. I don't know the full scope of all the requirements, but there are also OSHA rules that apply sort of by cross-reference through the H-2A rules for the basics of farm worker housing. How many beds to a room, how much space between beds, that sort of thing, walls, ceilings, heat, and those types of requirements. All right.
I have another.
But it's nothing on the federal law, right?
No, it is. So the H2A rules do include housing protections. Those are federal rules. I think we are right up against the 1:30 end time of the presentation. So
I have a question. I'm sorry. About the overtime. What happened if there are rules now in Virginia for the workers to get the overtime, and what happened with the federal laws? Could you explain me a little bit of that to be clear when the workers ask me the questions, and I would like to know what to say to them.
Well, I'll give you the 20-second answer, which is basically if there's a state law in place that provides greater protections than the federal wage law, that law will apply. So states can pass stronger protections than the federal law, and employers have to comply with it. Whether the issue is whether you have the right to, sue an employer in federal court over that violation. You may not, but workers do have those rights provided by the particular state laws, and there are a number of states, California, Washington, and others that have implemented some form of overtime protection for farm workers, and those same protections would apply to H-2A workers. So,
awesome. Yeah, we'll just wrap up. Thank you so much, Ben and Andrew. If you have some questions that weren't answered, go ahead and leave them in the chat and we can try to follow up on them. But also, as I dropped in the chat, we have 3 more sessions on H-2A workers. So if we didn't get to your question today, we might get to it in the next couple months. So please do register for those other 3 trainings, and we'll be sending you out that information along with the evaluation links within the next couple days. So keep an eye out for that. And just a big round of applause for Ben and Andrew. This was a super helpful presentation. I know I learned a ton. So thank you for sharing your time with us today. And thank you to everybody for attending, and we will see you next time.